What the world needs now is people. People who see things just a little bit differently, who go out of their way to find a new perspective and a new way forward. People who make faraway places feel closer with flight that's more fuel efficient. Who put the focus of healthcare where it belongs, on making patients healthier. People who see how more sustainable energy can power daily life while powering progress. Because seeing a smarter, healthier, cleaner world isn't something that's far in the future. It's something we're building now. GE, building a world that works.
Hello, my name is Gillian Fenton, and I am the President and Chair of the Licensing Executive Society. Welcome to the Society's 2021 annual meeting, which this year explores the theme of Reimagining the Future. I would now like to introduce our first two speakers, Senator Thom Tillis and former USPTO Commissioner Andrei Iancu. Senator Thom Tillis was first elected to represent North Carolina in 2014 and is currently serving his second term after being re-elected in 2020. Senator Tillis is a member of the Judiciary Committee and ranking member of the Subcommittee on Intellectual Property. He has worked to tackle the major issues facing America's IP system and to conduct rigorous oversight of the agencies tasked with protecting our nation's IP system. Andrei Iancu is an intellectual property partner at Irell & Manella. Prior to rejoining the firm in 2021, he served as the Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office. As head of the USPTO, Iancu oversaw one of the world's largest IP offices with approximately 13,000 employees and $3.5 billion annual budget. He previously spent 2 decades at Irell as managing partner from 2012 to 2018. Earlier this year, Iancu co-founded the Renewing American Innovation Project at the bipartisan Center for International and Strategic Studies. And now, Senator Tillis.
Hi, I'm Tom Tillis, Senator from the great state of North Carolina and ranking member of the Intellectual Property Subcommittee. It's an honor to be part of the 2021 Licensing Executive Society annual meeting and to speak with you today about the state of IP rights in Washington. I want to take a moment to thank Gillian Fenton for inviting me. I'm thankful for the hard work and dedication you and many others at LES have put into making this program happen. It's important to recognize and understand the very real positive impact that intellectual property has on our economy and in everyday lives of each and every person. America is the world's leading innovator, developing cutting-edge technologies, therapeutics, and treatments that have changed the world for the better and saved millions of lives. These successes are due in no small part to America's strong intellectual property system. In my view, our IP system is like a house built on a strong foundation. Its resilience and success inspires others to understand the importance of protecting IP. It also needs constant maintenance under strong leadership, and some areas are badly in need of renovation. For example, with the current global healthcare crisis, the administration's decision to support TRIPS waiver raises serious concerns for our intellectual property system. This is why I and my colleagues pressed the administration to explain its decision to permit the forced transfer of American technology, giving the house keys to anyone, including our adversaries like China. I firmly believe encouraging companies to license IP and engage in voluntary knowledge transfer are important and effective methods to help the global community without sabotaging our intellectual property system. We're waiting for the administration to appoint key intellectual property officials, including the USPTO director and the intellectual property enforcement coordinator. Senator Leahy and I sent a letter to President Biden asking him to prioritize the appointment of these key intellectual property offices. These individuals must have an understanding that intellectual property protections are just that, property protections, and be willing to commit to doing everything in their power to advance, promote, and protect our IP system. But we just can't be focused on having the right people in the right positions. Democrats and Republicans have to work together to enact the right policies, policies that will protect and promote intellectual property in the 21st century. In patent law, our greatest challenge is the current state of our eligibility and jurisprudence. As I've said time and time again, the current jurisprudence simply isn't promoting the type of research, innovation, and development in new and emerging technologies like precision medicine, 5G, quantum computing, and artificial intelligence. Why would anyone risk millions, if not billions of dollars to develop a product when they have no idea if they're eligible for protection? From a business perspective, it simply isn't worth the risk. That's why I'm focused on patent eligibility reform, and I'm doing everything I can to fix the Supreme Court's mess, from filing amicus briefs to working with the USPTO to improve the patent examination process. The United States can and will remain the world's leading innovative and creative economy in the 21st century. And to do so, Congress and the administration must make the necessary and tough policy choices to ensure we have the right framework to encourage and incentivize innovation. Please know that I'm ready to work with all of you to strengthen our intellectual property system and ensure that our country remains the premier destination for research, development, and innovation well into the 21st century. Thank you again for having time with me today.
All right. Hello, everybody. Pleasure to appear live, and always an honor to appear together with Senator Tillis, as well as Patrick Kilbride, who I believe will be following me. Thank you so much to LES and Gillian and Gillian Fenton and Brian O'Shaughnessy for inviting me to be with all of you. I've been with you in the past, and frankly, LES is such an important organization and does such important work that I always look forward to being with you at your events. You all focus on the practical use of intellectual property. After all, isn't that the ultimate point of a patent and other forms of IP? To use it to make or use new technologies, and if not, to license them out so that others can do the same and bring those technologies to market. The importance of intellectual property transaction has never been more important, never been more obvious that we need a robust IP system that encourages such transactions across the globe. Take our situation currently in the pandemic with respect to COVID-19 technologies. Cooperation around the globe is crucial to ensure that not only vaccines and other medical technologies get developed, but that they also get manufactured at the fullest capacity of the world's abilities and distributed equitably around the world. The system has the system overall, in terms of distribution of vaccines and other such things, obviously has certain issues that need to be addressed. Certainly, there is inequity in certain types of the distribution of certain products around the world, as between the wealthy countries and the developing world. But the IP system underlying all of it is working, and this situation is proving that the IP system itself, as compared to perhaps other parts of the manufacturing process, the IP system is working, frankly, better than ever. How do we know that? We know because industry is collaborating at unprecedented levels. Deals are being made at unprecedented scale. Companies of all sizes collaborating with each other, small companies and large companies. For example, BioNTech in Germany with Pfizer. Large companies with other large companies, such as Johnson & Johnson and Merck, collaborating for the manufacturing of the J&J vaccine. Cross-border collaborations, AstraZeneca and the Serum Institute of India. There are hundreds of these collaboration agreements around the world. Yet, as Senator Tillis mentioned, some have chosen precisely this moment in time to suggest that IP needs to be waived and removed entirely. This moment in time that we have arrived at because of robust intellectual property protections over many years and in fact decades. At this point, we sort of take the vaccine for granted. But I firmly believe that we would not have a vaccine to talk about in the first place, much less multiple vaccines approved in record time, but for a robust intellectual property system that enabled the investment in so many technologies for such a long period of time. There is no evidence that intellectual property has been acting as a barrier, as some have suggested. There is no evidence that removing IP will actually improve the situation. In fact, quite the contrary. If IP is removed, fewer deals will be done. If no protections are in place, and there is no rule of law to protect companies' investments in their technologies, why would private companies engage in the transfer of technology across the world, certainly at the scale that we have seen? What the world needs is more voluntary collaboration and cooperation, and that is only possible when the rule of law is respected. Now, of course, given the audience that I'm speaking with, you all know this. What is critical is for you all to make your voices heard. You are experts in these areas. It is important to explain to folks around the country, around the world, the issues and the importance of IP and what could happen if, in fact, IP is waived precisely at the time when it is needed more than ever. Innovation, especially in the United States, needs the private sector. And for the private sector to invest, it needs a reliable and predictable intellectual property system. Threatening to suspend IP rights precisely when needed threatens the entire innovation economy to potential great harm, not just to our economy, but to the healthcare and well-being of citizens around the world. The same is true with policies aimed at endless harassment of patent owners. Because if patent owners, once again, do not believe that they can meaningfully enforce their IP, that their IP will be, if they believe instead, that their IP will be attacked again and again without limits until either invalidated or until funds run out, then there will be less investment in patent-rich technologies. Some folks, instead, well-meaning folks who I know care deeply about the patent system, are being misinformed by some who want to return to the failed policies of the past. Failed policies that contravened the intent of the AIA and allowed multiple repeated attacks on a patent. How do we know that that's what they want restored? Well, because the changes we made only prevent such repeated attacks. Let me be clear. Our reforms that some folks are complaining about do not prevent post-grant proceedings, IPRs or PGRs, if the petitioner does not engage in repeated attacks. This is precisely in line with what Congress intended. Again, how do we know this? Because Congress told us. Let me be specific. During the passage of the AIA 10 years ago, Congress said, quote, that it recognized the importance of quiet title to patent owners to ensure continued investment resources, close quote. And Congress indicated that, quote, the changes made by the AIA are not to be used as tools for harassment or a means to prevent market entry through repeated litigation and administrative attacks on the validity of a patent. Doing so would frustrate the purpose of the section as providing quick and cost-effective alternatives to litigation, close quote. That is in the congressional report from the AIA. That is precisely what our policies do. And a reversal of some of those, as some are advocating for, would be a direct contradiction of what was promised in the AIA. And it would violate the balance that we need in the patent system so very much. What we need in the patent system, as in all IP system, is a system that ensures stable, predictable, reliable, and meaningfully enforceable intellectual property rights. It's across the board. It includes, for example, Section 101 of the Patent Code, as Senator Tillis mentioned. We need clarity so that we know, one way or the other, whether what we are working on, whether what our engineers, scientists, and inventors are working on is subject to patent protection or not. Our changes at the USPTO in 2019 provided such clarity within the context of existing jurisprudence. Our guidelines synthesized existing laws, existing cases, to provide a framework that is more clear, more predictable with respect to actions at the USPTO. The results have been extremely favorable. We know that anecdotally, we know that from examiners that have to examine hundreds of thousands of patents a year. We know that from the applicants. But more importantly, we know it scientifically now. A report published by the USPTO's chief economist several months ago indicates that in the first year since the introduction of the Section 101 guidelines at the USPTO, the inconsistency of examination has decreased by 44% in the first year alone. That is a remarkable performance. Now, of course, the courts are independent, as they should be, and they're not bound by our guidelines. And the jurisprudence that has begun about 10 years ago continues. And as Senator Tillis mentions, it has been the source of confusion in Article 3 proceedings. So if the courts do not provide additional clarity, then there is only one other branch of government that is left. And we probably need legislation at that point in order to address the state of Section 101 law. And I am thankful that Senator Tillis and others are engaged in this effort. However, I urge cooperation between stakeholders in order to create consensus. Those who believe that Section 101 needs to be reformed, those folks at a minimum need to speak with each other with an open mind and drive towards consensus in order for legislators like Senator Tillis to be able to create and craft legislation that works for all. But these are just some of the issues that face the country when it comes to innovation and intellectual property. Let me mention one of the key areas of the technologies of the future: artificial intelligence. Obviously, from an operations point of view, the USPTO has adopted and is in the process of adopting even more artificial intelligence tools for the processing of patent and trademark applications. While I was there, we worked on many such tools, some of which are already in production and are being used. For example, automatic classification using machine learning technologies are saving the USPTO incredible amounts of time and millions upon millions of dollars every year. And that's just the beginning. There are artificial intelligence tools being used and created for prior art searching and for the identification of fake specimens on the trademark side, and so much more. To everybody in our field, in the intellectual property field, watch this issue, because the use of artificial intelligence tools for the examination will have a lasting and significant impact on the way we practice law, both on the prosecution side and then additionally on the litigation side, and of course in transactions when the two sides, the licensor and the licensee, look at the same property through the lens of the same or similar artificial intelligence technologies. They can assess the validity and value of those technologies. Of course, the administration and the US government in general needs to address the use of artificial intelligence in many different ways. There are lots of intellectual property issues, such as issues of who the inventor is, ownership, who would own technologies created by AI machines, and those of skill in the art, who is one of skill in the art if the inventor is an AI machine. So many other issues. We published a report to the USPTO in the fall of 2020 that addresses some of those issues and sets forth the current views of the public. But significantly more needs to be done. And I encourage the government to attend to those issues sooner than later, before the events overtake us. There's so many other technologies that are impacting our field, such as blockchain and nowadays NFTs as well. All of us in the field need to watch this. From a higher level in the United States, in my view, needs immediately a national innovation policy, obviously focused on the technologies of the future, such as artificial intelligence, 5G and 6G communications and beyond, autonomous vehicles, quantum computing, biotechnology, personalized medicine, and so much more. IP, of course, is a component of such an innovation policy, but only one. There's so many others of critical importance. For example, manufacturing and supply chains. Look where we are now, where there is a dramatic shortage of silicon chip technologies and components that is impacting our everyday lives right now. Those issues need to be addressed, and they go well beyond silicon chip technologies. In addition to that, we need to attend to standards and standard-based technologies. Again, 5G, 6G are just some examples. But in the world of the Internet of Things and so many other technologies of the next industrial revolution, standard-based innovation is at the core of any innovation economy, and our leaders need to attend to that to ensure that the United States is in the best place it can be in order to compete on the world stage at the highest levels. We need to attend to STEM and innovation education to ensure that our next generation of inventors and entrepreneurs have the proper educational backgrounds in order to be able to compete. And those education efforts cannot be localized. They need to be broad-based, both demographically and geographically across the United States, to give a chance to the entirety of the US population. And along the same lines, the United States needs to focus on a diversity and inclusion and overall expansion of innovation and entrepreneurship in the country. Innovation is highly concentrated in the United States. While I was at the PTO, we published 2 reports on the status of women inventors named on US patents. And what we know is that in 2016, only 16% of inventors named on patents filed that year were women. 12% in 2016 were women. By 2019, it grew to 13%. Definitely a move in the right direction, but so much more to go. So much more work that needs to be done. Racial minorities are likewise not participating nearly to the same levels as the rest of the population. Neither are folks from various communities across the United States. This is why we started at the USPTO, the National Council for Expanding American Innovation, to help the PTO create a national plan to address some of these issues. I can't emphasize enough how important this is. It is important, obviously, for the individuals themselves, because we know people who participate in the innovation economy have generally, on average, much better careers and much better access to higher paying jobs. It's important to the companies they work in and the communities they work in as well. And it is of absolutely critical importance to the United States as we compete on the world stage for technological leadership when it comes to the technologies of the future. Otherwise, if we don't attend to these issues, we will be left behind because the rest of the world is not waiting. The rest of the world is racing ahead in a planned effort to lead as best as they can in all of these areas. Having said all that, I'm incredibly optimistic about the future of this nation when it comes to innovation and entrepreneurship. There's tremendous potential in the people of this country, their creative spirit, their entrepreneurial spirit, and the freedoms that our system affords to all to try new things and to try to succeed, even if sometimes they fail, and no matter how hard it might be. What we have to do as leaders in the field, what we must attend to is to ensure that we unleash this tremendous potential and that we work on forward-looking policies that create more and more opportunities for American inventors and American investors who are working to fund and create the technologies of the future. Thank you again for the invitation to be here with all of you. And thank you for what you all do for this system and for the American innovation economy. Thank you all. And I think now I'll turn it over to Patrick, and the panel he will be leading.
Thank you, Director Iancu. My name is Scott Williams. I'm President and Chair-elect of LES USA Canada. Joining us to close out our keynote session today is Patrick Kilbride. He is Senior Vice President of the Global Innovation Policy Center at the U.S. Chamber of Commerce. There he oversees the center's domestic, multilateral, and international programs and leads GIPC's policy work to promote intellectual property-driven innovation and creativity. Previously, he was Executive Director of America's Strategic Policy Initiatives and Executive Vice President of the Association of American Chambers of Commerce in Latin America and the Caribbean in the Chamber's International Division. He served in the Executive Office of the President during the George W. Bush administration as Deputy Assistant U.S. Trade Representative for Intergovernmental Affairs and Public Liaison. At USTR, he worked with state and local officials, business organizations, and non-governmental organizations to advance the president's trade policy agenda. Earlier in his career, he held various private sector roles advocating on behalf of business for rule of law and market openings through free trade agreements. He is a graduate of the George Washington University and resides with his family in Alexandria, Virginia. Please welcome Patrick Kilbride.
Thank you very much, Scott, and thank you, Director Iancu. It's always an honor to have the chance to appear on the same platform as former Director Iancu, a true leader in the IP community, as well, of course, as Senator Tillis, who's been such a stalwart for the system, the intellectual property system, in his time in Congress. And, Director Iancu noted that the system has worked in the pandemic. And I think that's true. We've seen how important and powerful the intellectual property system is to enable technological advancements that provides solutions to technical problems. In this case, immunity to a previously undiscovered virus. But in many ways, the system's not working. And I think that's part of the reason we've convened today, is because in too many places, the system simply hasn't been implemented. And even here in the United States, where we've seen the almost miraculous results of a functioning system, the intellectual property system is under duress in many ways. And Senator Tillis and Director Iancu talked about some of the challenges for jurisprudence up to and including the Supreme Court. They talked about the challenges of congressional stewardship of the intellectual property statutes. They talked about, maybe they didn't talk about, but I certainly will, some of the challenges that we have within the U.S. business community. And the question I think it raises is the system working today for our economy? And I think the answer is probably somewhat complex. In many ways, we see that the abundant evidence that the system is working, and it begins, but is in no way limited to the vaccines that we saw from Pfizer-BioNTech's partnership, from Moderna as a small, medium-sized biotech company, from established players like J&J and many others around the world. And yet at the same time, we're having these existential debates about intellectual property policy and the workings of the intellectual property system with significant players in the U.S. political system and in U.S. industry taking positions that would see the intellectual property system weakened. And that, to me, is evidence that we in the IP community have work to do. When we look at the way that too many companies approach IP today, it's from a defensive posture and not an offensive posture. And we need to correct that. We need to make sure going forward that the intellectual property system is working for everyone. I believe that that comes from a proactive and expansive view of intellectual property. And I really think it begins with the folks that you represent at the Licensing Executive Society, because you understand better than anyone that intellectual property is only as good as the reliability and the fungibility of the asset. On the last occasion where I had the opportunity to speak with the LES annual meeting, you were in beginning stages of setting up a process for standardization of intellectual property licensing. I think that work is incredibly important because at its root, the system is working when it enables the allocation of resources to high-risk, long-term, capital-intensive activities. We see that very pronounced in the drug development space, where decades are invested in the creation of not only new medicines, but new technology platforms, such as the mRNA platform that could be unleashing a whole host of new cures. We see that across many different areas of technology, not just medicines, but communications, and a whole host of other applications. But we know that those resources can't be invested unless the resulting assets are transferable. That is, an innovation ecosystem only works when assets can be created in the first place, but then they can also change hands. That there's an ability to form partnerships for one entity to continue to specialize at the things that they do well and hand off an asset to others who can continue to take it forward. That is the essence of the highly successful system of IP commercialization that we've seen in the United States, and that in many ways is under duress today. When we look globally, we see an even bigger challenge. Really, I think, emblematic of which is the proposal to waive the WTO TRIPS agreement. And those of you who, all of you really, who are in the IP space, who work with this every day, know that TRIPS was conceived as a floor, as a minimum standard for global intellectual property rights. It was a chance to harmonize a base level of intellectual property protection across all WTO members. And yet from its entry into force more than 25 years ago now, most WTO members have never been required to implement the TRIPS. And moreover, large portions of the commitments have been waived ever since for many of the other countries. So what does that mean? Well, it means globally, not only is the system not working, it hasn't actually been tried. And we see the results of that today in the pandemic. There's obviously a push for the waiver of patents related to COVID technologies, vaccines, plus medical devices, plus so many other essential tools. And then a quick realization that simply waiving patent rights wasn't going to be enough. That what we really needed in order to expand global production was technology transfer. And so you see the goalpost moved into calls for forced technology transfer with the establishment of nominal technology transfer hubs around the world. Well, we in the IP community know that simply requiring technology transfer does not result in technology transfer. And how do we know that? It's because we see the diffusion of knowledge and technology every day through the work that you're doing. And we see how it works organically, voluntarily, almost through a process of osmosis from our educational system that trains scientists, researchers, engineers, that trains business people with the understanding of business processes and their relationship to manufacturing and supply chains. And we see capital markets that are extremely savvy about allocating resources to areas of opportunity. And when all of those things come together, we have a highly functioning ecosystem for innovation. The same is true in the creative sectors. But it only works because all of the pieces are in place. And as we look around the world today and see the unevenness of vaccine production, just to pick on one area, we know that if many other countries want to be part of that ecosystem, they have to be bought in on all of the elements of the ecosystem, from the capital markets to the education system to the profound respect for intellectual property rights that allows transactions to take place within the ecosystem. Because, we see this diverse community of contributors to IP commercialization from the governments, who are often early stage funders of basic scientific research, to the universities that are carrying out both basic research and applied science, to the startups that are seeing a promising advancement and carrying it forward, to the larger companies like a Pfizer that has the capabilities to quickly recognize an opportunity to scale up manufacturing processes, to do clinical trials, and actually deliver a product to market. And all of these different constituents have to be able to do business together in order for that system to result not just in a good idea, but a product that can actually reach people and save lives. We've seen how effectively it can work in the pandemic, and we've also seen where it breaks down. So the government of South Africa, for instance, is not asking my advice on how to encourage technology transfer to would-be South African manufacturers. But if they were, I would say very clearly, make a strong political commitment to the TRIPS agreement rather than asking for its waiver. Stand up and say, we see clearly that intellectual property rights are the currency in a knowledge economy that allows collaborations between a very wide-ranging group of stakeholders. We're going to signal our strong support for IP rights. We're going to signal our investment in basic research so we can contribute to the advancement of knowledge. And we're going to be a player and a partner in this functioning ecosystem rather than trying to tear it down. When that happens, then I believe you'll see the types of the expansion of global production capacity that is so desperately wanted and needed today during this pandemic. Now, in terms of the broader system and where the United States is today, Senator Tillis and Director Iancu said a number of things that I thought were extremely important. I'll start with the idea of quiet title. From the U.S. Chamber of Commerce, our strong position has been that the most important factors in a functioning IP system are transparency, predictability, and reliability. Words that you hear from Director Iancu again and again. Transparency. I think we are at a place where we need to find ways to inject more transparency into our system from the very beginning. Director Iancu spoke eloquently about some of the ways that the examination process has been improved. I believe will continue to improve through technological tools like AI. I think it is just tremendously important that we are able to apply those tools and able to create an environment where no one is surprised by IP ownership. Large companies should not be stumbling over previously, unknown patents that are being asserted in ways that may or may not be, applicable or legitimate in that case. We should be able to know very clearly in different technological areas what the state of the art is, and all be able to recognize what a real advance of that state of the art looks like. And I think that's the kind of transparency that that artificial intelligence promises to bring. So as I look at the system from very basic stages, I sympathize with the efforts to enhance patent quality on the front end, because I believe so strongly in the importance of having a presumption of validity on the back end. When you as an inventor, whether it's an individual or inventor or a company, are granted a patent by the US government, there should be very little doubt about the validity of that patent. And to the extent that, in the past, patents have been granted that were overbroad or vague, and we have the tools from the AIA to help to clear that up, great. The Chamber in 2010 supported passage of the AIA for that very reason. I think we also saw clearly that in implementation, and especially in conjunction with some of the decisions by the Supreme Court on eligibility and other issues, that the pendulum swung back too far against intellectual property rights holders. Director Iancu, to his credit, did yeoman's work in trying to bring that back to center, which is why we supported that so strongly. And during his tenure, we saw the United States regain its leadership in the patent categories of the U.S. Chamber International IP Index, for instance. So going forward, we need to talk as a business community, as an intellectual property community, and really understand why it is today that so many important players within U.S. industry are not relying more on the intellectual property system. What is the failure, the market failure that we've not yet addressed that has led them to take such a defensive posture? I believe, and this is a personal view, that the system has not continued to grow with our economy. And what I mean by that is, when you look at the area of intangible assets, of which, patents, copyrights, trademarks are a subset, what are we doing to make sure that a much broader class of those intangible assets can be accurately identified, can be valued, can be protected, can be traded? And I'm not, suggesting that we need to create a whole new system of registering rights, but I am suggesting that we need to be very thoughtful in making sure that a broader class of assets can be protected and made part of a functioning intellectual property system where rights and skill sets and know-how can be licensed. Because an asset that can't be traded is, in effect, not an asset at all. It's simply a tool. An asset can be leveraged. We see this around the world in so many ways with the informal economy. We see billions of people around the world with abundant possessions, but they can't be leveraged as assets. And when governments provide a strong rule of law environment, when they provide the basis for financial access and inclusion, then you see these dormant assets come to life. I think where we are today in the global economy is in the same place with knowledge assets. Too many of them are dormant. We have to be able to bring them to life. The way to do that is through the work that you do, the licensing of IP and prospectively a broader class of intangible assets. So as we look at the state of play in the United States, and then more broadly on a global scale, I think the first thing is we need to step up together as a community and to the defense of the TRIPS agreement, because it would be an absolute mistake to waive the very IP, the commitments to the very IP standards that enable the types of collaborations, partnerships, resulting in technology transfer that the world needs to gain the outcomes that the WHO, that the United Nations, and so many others are calling for. But the United States further has to lead. We have to be the one to point the way forward. We have really disengaged from the multilateral trading system and from the world to a degree that's been shocking. And at a working level within our civil service, I think they've done yeoman's work to keep us at the table. But from a political level, we've failed. And I think you see that more than ever today with this America First mentality that really hasn't gone away with changes in political administrations. More than ever, we're looking inward. We're very insular, and we're failing to recognize the cost of letting that leadership lapse. The chamber, the GIPC, runs intellectual property cooperation dialogues now with China, which we've done for more than a decade, with India, a newer effort, but that's now 4 or 5 years old. And we see these countries grappling to come to grips with these intellectual property issues, and in many cases a deeper set of issues where they're a little bit ahead of us, frankly, in having a national dialogue on data flows and data ownership, on intellectual property relating from AI, on intangible assets and use of IP as collateral, and a whole host of other issues. We've seen countries like Singapore and even China, in some cases, take on a leadership mantle. And the challenge here is that we could find ourselves in a global system that has been defined by other players. That's not an acceptable outcome from my point of view, because the United States, for all of its shortcomings, has been better than anyone else in the world in creating a market economy for a whole host of technological advancements up until now. We are better than anyone else in the world at allocating resources to the next best thing. But it was founded in a tremendous sort of iconic respect for inventorship, entrepreneurialism, and frankly, market economics. And as we get into a more sort of existential global competition with philosophies, political and economic philosophies that are antithetical to everything that we've achieved here in the United States, we cannot concede the field. It is just incredibly important that we continue to do the things that we have done best: to make markets, to move capital, to invest in education, and let our people do their work. And if we can do that, like Director Iancu, I am tremendously optimistic about the future of our economy and the future of U.S. technological leadership. But we really do have some work to do today to make sure that continues to be the case. So I'll stop there, and thank you to Scott and Arpi and the team at LES, and thank you, Director Iancu. It's always a pleasure to be with you.
Thank you, Senator Tillis, Director Iancu, and Patrick for your valuable insight. We appreciate you joining us this morning to kick off the 2021 annual meeting. Many of the issues raised in these remarks will be explored in depth in panels this week. So we at LES hope that all of you will join us and participate in the discussion, both during the panel and as well as on our social feed. So welcome again to the LES Annual Meeting 2021, and we hope you'll enjoy the panels. And now we take a 5-minute break, and then we'll go into our next panels. Thank you.